Welcome to Q&A, Social Security Disability Today. This program is brought to you by the Reeves Law Firm, representing you and your Social Security and disability needs. If you have a problem or questions regarding Social Security and disability, call attorney Anthony Reeves. Here's your host, attorney Anthony Reeves.
All right, this comes up a lot. Why are grid rules so important if you're over the age of 50? And I've got a couple of attorneys who post here and respond here, and I want to say thank you very much because I'm always a big believer in education. So the more comments and feedback you have to either expound upon or even correct what I'm saying, much love for you because I always appreciate that because I want people to come here and be able to read and hear things and know that they're getting good information. There are guidelines within the federal regulations. It's called the Medical Vocational Guidelines. It's what we in the Social Security field call the grids. And what it is it's basically, it's a chart that basically has certain information over the top and certain information going down. Here's what I mean. Over the top is going to be your age, your education, your work experience, and whether or not, based on those three things meshed up, whether or not you're disabled or not disabled. Each one of these charts are basically put in categories of sedentary, light, medium, and those are the primary that I typically work with. Now, why is this important? Well, I always tell people that, and this is what most representatives will probably tell you, once you hit the age of 50, the grids become important because for the most part, you don't need you're not going to see a lot of reliance on the grids if you're under the age of 49. Because for the most part, if you look at all the grids in terms of different models, meaning your age, education, your work background, they're going to find that you're not disabled. What happens is once you hit 50 and above, there's the category of basically 50 to 54, 55 to 59, 60 to 64. Those categories, if you meet certain criteria, may direct that you are found disabled. So in other words, where these guidelines are not helpful to you if you're under the age of 50. Once you get into the 50-ish range, it becomes helpful. Let me give you a good example. If you've got someone who can only do sedentary work and they're 52 years old and they have less than a high school education, okay, and they've done work but they acquired no skills from that work, okay, that allows for direct transferability. Let's say that all the work jobs they did were unskilled and they were all heavy. The regulations dictates that under that example, the person must be found disabled unless there's evidence to the contrary. It's amazing. You take that same set of facts, say somebody who is 39, less than high school education, and doesn't have any skilled work, the regulation says you're not disabled. Now you say, that's wow, wait a minute. So a 10-year difference, 11-year difference makes a difference? Absolutely. Because the regulations takes into consideration this. Think about it. Most people, for purposes of their working life, at a minimum, probably start working in their teenage years through up to about 50. So the idea is once you start getting into the 50 and above range, the ability of an individual to assimilate to new jobs becomes more difficult. Why? Let's stop and let's think about it. You've been in the workforce for about a good, 30 years? So certain things are going to become integrated within you. So when they're looking at the work you've done in the last 15 years, if you don't have anything that you could transfer to that particular skill set, they're going to look and they're going to say, when I say skill set, they're going to look at those different categories and they're going to say to themselves, based on this person's age, education, work background, and what their limitations are for their RFC, meaning they're limited to sedentary or light, the regulations may direct that a finding of disability is more appropriate than non-disability. So I always tell my clients, especially when people come to me and they say 50, they're 50 and above, I always say 50 is the magic number because at that particular point, there are additional guidelines that Social Security relies upon, i.e. the grids, in order to make a determination of whether or not you're disabled. The determination of you being disabled becomes a little bit cleaner if the evidence supports it. So that's why I tell people all the time, you're under the age of 50, don't even sweat it because you're 18 to 49 is the golden working years. They're going to probably find a job for you to do anyway. But when you're over the age of 50, those things become important for purposes of utilizing the vocational guidelines to assist Social Security in determining whether or not you're disabled. Those guidelines literally provides that in certain instances, Social Security should find that you are disabled. So you being 50 and above becomes a more magical and a helpful number for you for purposes of being found disabled, for the possibility of being found disabled.